My name is Carolyn Jones. I'm the Director of the Institute of Employment Rights, and I'm very pleased to welcome you to this very topical event tonight. It's not only topical, this event, but it's also timely. As you will be all too aware, the UK is in the final throes of negotiating the terms of any future post-Brexit arrangement with the European Union. Tonight we will be discussing those UK-EU negotiations, but we will also be raising our focus above and beyond Brexit to look towards the terms of future trade deals with other countries around the world. Be assured the Institute will be addressing the post-Brexit world of work in the new year and assessing the implications of whatever deal is done for UK workers in the future. One thing I think we have learned from our relationship with Europe is that once freedoms and interests of business are allowed to take precedence over the interests and freedoms of workers, then any promised benefits to workers from the arrangements invariably come under attack to the detriment of the workers. I'm sure everyone here tonight would agree the free market does not deliver on its trickle-down theory. Wealth and well-being do not trickle down to workers unless they are demanded. Even the IMF and similar bodies now openly acknowledge the role of trade unions in ensuring a fairer distribution of the fruits of labour and the need for a level of pay that will help build a sustainable and strong economy. So we also understand the role of the state in regulating standards. So across many areas, whether that is health and safety, food, climate, or the delivery of services, the state has a role to play in delivering on standards. At the Institute, our focus is on those regulations that impact on workplace rights and trade union freedoms. We look to international standards and best practice and measure the extent to which the UK is meeting those standards. Unfortunately, the UK's framework of employment rights and union freedoms has consistently failed to meet international standards and has been criticised annually by those international bodies tasked with monitoring such labour standards. So it doesn't bode well for the future UK trade deals. But not to be deterred, unions are reaching out to trade unionists around the globe to ensure that all unions, no matter which country, aim for a set of core principles in trade deals that protect the rights and living standards of workers. Principles including the promotion of good jobs, respect for fundamental labour standards, including freedom of association, ensuring trading partners sign up and enforce workers' rights, and the protection of public services from further privatisation, deregulation and outsourcing. That is the trade union agenda. But how do we win it? How do we raise the bar and avoid a race to the bottom in labour, climate, food and other standards? And tonight, our speakers bring a wide range of experience, knowledge and understanding to the platform to help us consider how to achieve our goals. Now, I said we're short of time, 4 speakers, 1 hour. So at that point, I'm going to move swiftly on to our first speaker. And our first speaker for tonight is Ruth Bergon. Ruth is the Senior Advisor at the Trade Justice Movement and has worked on trade policy and trade deals for the past 11 years, covering issues including trade with developing countries, TTIP, the US trade deal, and more recently, EU and UK trade negotiations. She has most recently written a report on trade and climate change, due out early next year. Hopefully we can put a link to that in our chat box, highlighting the need to ensure these 2 agendas are aligned ahead of the climate change conference due to take place in Glasgow, I believe, next year. So Ruth, the floor is yours.
Thanks, Cad, and thanks very much to the Institute for Employment for organising this. So my task is to set out in broad terms what trade deals are and how they impact on workers' rights, and I'll try and keep to my 7 minutes. So trade deals are international agreements between 2 or more countries. So the UK-EU deal, should it appear, is a bilateral deal, as is the UK-Kenya deal, recently signed, and UK-Canada recently rolled over from the EU. You also have what are called plurilateral deals. So the CPTPP. Trade is a world of acronyms, which you will grow to love if you spend any more time thinking about this. But the CPTPP is the Comprehensive and Progressive, apparently, Trans-Pacific Partnership Agreement, which bafflingly the UK wants to join. That's a plurilateral. It has a number of countries, 11 countries. And the WTO is multilateral. So that's 164 countries who've all signed up to WTO agreements. And the primary aim of trade agreements is to make trade easier for private companies. So they offer significant benefits for companies, and the logic goes, I think as Cad was referring to, the trade agreements will lead to growth, and therefore we all benefit because of course it all trickles down, and isn't that fabulous? These trade deals that offer, they offer reductions in tariffs, but also the opportunity to access other countries' procurement markets, their services markets. It offers standstills effectively on regulation, and also sometimes downward pressure, so that it's easier to do business because you have, let's call it a more in business language, it's always called a more stable regulatory environment. So all of these benefits are offered to businesses with absolutely nothing to condition their access to those benefits. So it doesn't ask them to adhere to international labour conventions in their supply chains. It doesn't ask them to respect environmental laws. And if they break any of those, the trade deal has nothing to say about business practices. Since the mid-1990s, and this is something that I think is really important to remember, through the establishment of the WTO and the North American Free Trade Agreement, you see trade deals moving way beyond just dealing with tariffs. So the taxes you pay at borders for importing goods reaches much further into really all aspects of everyday life. So that's where you get services, including public services, and you have seen the debacle around the NHS last year, the water wars, many of you may remember back from the 90s, investment, intellectual property. So interestingly, the trade world likes to liberalize, except in one area, which is intellectual property, where it likes to do the opposite and offer much greater protections for business. So you'll have a patent for 20 years instead of 5, say. And this is a big argument that's happening at the moment with the WTO in terms of the COVID vaccine. The other thing that's really important to remember about trade agreements is that they are both binding and enforceable. You will do the things that you say you will do in the trade agreement, and if you don't, your partner country or countries have all the tools they need to hold you to account. They can raise tariffs, they can take retaliatory measures that will damage your businesses, and they are regularly used. If you look at the WTO, lots of cases happening around, say, solar panel measures in various different countries. This is in stark contrast with most of our other agreements on labour rights, on the environment, on climate. They are not binding and they are not enforceable. And we're told that it's not possible to do that because it's just far too complicated, right, to actually get people to sign up to legally do things. But we can do it when it's trade. The last thing to note, just in terms of labour rights, is that labour chapters are increasingly a feature of trade deals. Now, the analysis that I've seen of these by someone who's also called James Harrison from Warwick University, says that basically they are, first of all, often the enforceability mechanisms of the trade agreements don't apply to the labour chapter. So EU labour chapters are basically not given any enforcement mechanism. US chapters are a bit different, they're more enforceable. However, they are all conditioned to look at whether a labour rights infringement is trade distorting. So the only way you can action the protections is if your labour rights infringement caused and can be shown to cause a change in your benefits from trade. And so there's one case that's ever been brought against Guatemala, and the findings were that yes, indeed, there were labour rights violations, but no, the trade deal had nothing to say about it because it didn't affect trade. So that's how good they are. So how trade agreements impact on workers' rights? Well, one, they don't do anything to protect them, as I've just established. There is acknowledgement that trade deals lead to winners and losers. So if you look at EU sustainability impact assessments, they often reference that. They will look at job creation and job losses, but it's in a very macro way. And there's often a series of very odd assumptions about what happens. So you see sort of, for the TTIP deal, there were going to be gains in leather, textiles, insurance, and a number of other areas. and losses in things like electrical machinery, non-ferrous metals, iron and steel. But the assumption tends to be that workers in the sectors that are losing will transfer more or less kind of seamlessly into sectors that are gaining. And there's very little done to sort of look at how difficult that's going to be, whether it requires workers to move region, how they're going to develop the skills to move sectors. So often just the bits and pieces are not there to make sure that kind of transfer can happen, or even to assess how realistic it is. Beyond the impacts on the ground, I think there's also a question about what signal you send when you do a trade deal with a partner. So we know, for example, that the US has only signed 13 ILO conventions, and of those that it hasn't signed, I mean, some are pretty critical. So you have, it hasn't signed the ones on forced labour, the right to organise, and on discrimination. They're pretty crucial, and yet we're quite happy to charge ahead with a trade deal that offers all of these benefits to businesses. And in contrast, when it comes to former colonial countries, the EU and the UK are very happy to impose, through some of its agreements, a requirement that they sign up to certain ILO and other conventions. So there's a real kind of, difference in terms of who the most powerful are and how much we're willing to impose on them. So just a final point is that at the moment in the UK, whatever we think of the labour rights impacts of trade agreements, there's not a lot we can do about it, because the UK has some of the weakest provisions for scrutiny in the world. And this is something we've been working on for 4 years. And we sort of thought that all we were doing was offering a sort of sensible process that was reflective of what happened in the EU and the US, but it's been resisted sort of completely by the government and by Conservative MPs. So we are supporting at the moment amendments to the current trade bill to try and get those processes in place so that Parliament can see and vote on a mandate, so that it can have sight of negotiating text, because that's the only way you know what the real impacts of these trade deals are going to be. And so that they have a final vote. Parliament doesn't even have a final vote on the trade deal. And that includes, by the way, the EU-UK trade deal. Whatever we think about the shambolic process we're going through, I think not enough has been said about the fact that there is now not enough time for Parliament to scrutinise this deal. There isn't even any commitment to have Parliament look at it, let alone vote on it. And that's how it's going to be for other trade deals, unless we can get a change. And what that means for workers' rights is that, I know that the TUC and a number of other unions are represented on various government groups, as are we, consultative groups. But really, there's no guarantee that anything of what we say is taken into account, and we can't get our voices heard through Parliament. So, there we go. That's my overview. I'll stop there.
I nearly forgot to unmute myself then. I was listening so intently. Thank you very much for that, Ruth. Thanks for that whistle tour run through the acronyms and the features of trade deals. Very informative. You've told us about the inbuilt contradictions and weaknesses, certainly on trade union and labour standards, and the power grabs that are there between powerful countries and those less so. Anything that we can do at the Institute to spread the word about your campaigns, we'd be only too happy to do. So send us a blog, send us some links, and we'll have them up on our website and circulating around our list. So thank you very much for that. I'm sure there will be a lot of questions put to you in the blog. I will move on to our next speaker. Our next speaker is Jeff Vogt. Jeff is based at the Solidarity Center in Washington, and he is the director of its Rule of Law department. Previously, Jeff was the legal director of the International Trade Union Confederation. I think that was between 2011 and 16. So he has a strong background on both international standards and trade unions. He also helped put together a recent book on the right to strike and international standards, which he did with some IAR colleagues, John Hendy and Keith Ewan. So yeah, you get a plug on here, whether you ask for it or not. So now Jeff is going to share his knowledge of a new US-based free trade agreement, which replaces the current NAFTA agreement governing trade in North America. It's the USMC agreement, which has been negotiated by the governments of the United States, Mexico, and Canada, and Jeff is going to highlight to us its strengths and weaknesses and perhaps things we might learn from it. So over to you, Jeff.
Great. Thank you so much for the invitation to this panel. I really appreciate it, and the opportunity to learn from my other panelists. As those of you who kind of know my work in this field, my writing, you know that I'm very much often a critic of the trade and labor standards and linkage that have been incorporated into both US and EU-based trade agreements. With the US, the standards obviously being weaker with stronger enforcement, and the inverse with the European agreements. Much of what the criticisms raised by Ruth in the earlier panel, I agree 100% with. Yeah, I do think though there's kind of an interesting development that has happened in the United States with the USMCA this year, I think, which does reflect some positive developments. Whether these developments are obviously going to offset all the other issues that we have with trade agreements, of course not. But I think with regard to the specific issue of labor, I think while not by any means a perfect chapter, it does reflect some learning from past mistakes, and does, I think, provide some potential concepts that could be incorporated into UK, EU, Canadian trade agreements. To the extent that we can continue on this this approach. So I know I've only got 7 minutes, probably now 6, so I'll be very brief on the presentation, and I'll be happy to take any questions after the presentations. So as you know, the NAFTA in 1994 introduced the first real kind of trade labor linkage in this North American Agreement on Labor Cooperation. And since then, the U.S. has gone through various iterations of labor chapters. I think with the latest one we have arrived at, we do see that it's trying to react to a number of kind of lessons learned from the previous 25 years. I think one, with regard to the standards in the agreement, I think one important aspect of it, and it goes to a point that Ruth had just made, we did see this kind of disastrous outcome in the US Guatemala arbitration, where it went on for 300 pages detailing the ways in which workers and trade unions had been kind of brutalized in Guatemala, but said, well, it wasn't done in a manner affecting trade and trade between the parties, so we can't do anything about it. Sorry. Now there's the USMCA's labor chapter has recognized that was a ridiculous interpretation, and now is it just states that to the extent that the violation takes place in a tradable sector between the two countries, that is sufficient for a matter affecting trade, and you don't actually have to do the economic analysis to show that there is some distortion in the trade between the countries. I think another important development was that in many of the cases, including the one in Guatemala, we had raised the issue of anti-union violence. This had been usually treated as a criminal matter in the jurisdictions in which these issues are raised, and not as a labor law matter. The U.S. has taken a kind of narrow view of what labor law means in the context of the trade agreement, and neglected to raise the assassination of trade union leaders as something that was actionable under the trade agreements. That has been fixed. There is now, in fact, going back to the original NAFTA labor side agreement language with regard to providing kind of equal protection. Doesn't say that quite, but the migrant workers should enjoy protection under the laws in which the countries are working. And it also requires the 3 countries to adopt a kind of what the US already has, is a ban on the importation of goods made with forced labor. Canada has already adopted legislation in that regard, and there's a kind of a tri-national committee that's been established to take a look at the import of forced labor-made goods. Another, I think, important development was an annex that was incorporated into the agreement, which requires, in this case, Mexico to ensure that it passes legislation to eliminate protection contracts. These are contracts which have facilitated employer-dominated unions for the last 100 years to dominate industrial relations in Mexico. There were constitutional reforms a few years ago and major federal labor law reform, which, while not perfect, makes it more difficult or gives workers greater opportunity to form democratic and independent unions. That legislation has passed, and the Constitutional Court of the Supreme Court of Mexico has just recently upheld those reforms. So that was another important advancement. But I think the kind of more interesting piece of the new USMCA is on enforcement. The original NAFTA labor side agreement actually did usually focus in on specific cases of violations at a specific factory, sometimes a sectoral level. There were a couple of complaints that were looking at kind of generalized issues or legislation, but most of them were factory specific. In all of the trade agreements that subsequently were negotiated, the trade agreement complaints really needed to focus on systemic countrywide problems in law or in practice, in part to show this kind of this recurring, sustained and recurring kind of violations. You couldn't just point to one. You needed to show that this is part of a pattern of the government. The new USMCA does maintain this possibility of doing a kind of a broad complaint against a country, with the possibility of these cases leading to arbitration, and if the arbitration sustains the complaints and there is no remediation at the end, there is a possibility of trade sanctions. I think the more interesting thing is that in addition to this traditional process, you now have the ability to enter into trade disputes over single workplaces. So there's a kind of a new rapid response mechanism that has been set up. It's called the Special Facility Specific Rapid Response Mechanism. And this allows a petitioner to say, there's a violation of freedom of association or collective bargaining. Those are the rights that are covered under the special mechanism. And it's in manufacturing, services, and mining, that there is a union has been busted in factory X. A complaint can be filed. The U.S. trade representative would then take it to its Mexican counterpart, say, look, here's this allegation. You have an opportunity to address this under your own system first. If that doesn't work, there is potential for bilateral review. And I'm being very simplistic now because of time, there could be state-to-state consultations over the violations, but in the end, it can go to a panel of experts, which can, on the basis of the evidence presented by both parties, issue a sector or firm-specific sanctions, so that if you have a union has been busted in a manufacturing facility in northern Mexico, and the panel upholds the finding that there has been a violation, and Mexico and the Mexican government has failed to bring this factory into compliance with the rights under the trade agreement, the U.S. could suspend the preference, the preference to that firm. So if there was a 8% reduction in tariffs under the agreement, it went down to 0, they can reapply the tariffs. Or if it's if this happens repeatedly, they can in fact block those goods from entering the United States. So it does create a particular incentive for bad actors to comply. And you don't have to go through, like in the case of Guatemala, a 9-year dispute only to lose the case. And even if you had won the case, 9 years a process, which only then really has an impact directly on the state, doesn't provide much incentive for private entities to act in accordance with the commitments under these agreements. This kind of special facility, I think, does provide that incentive. There has been no case yet filed under it. I know trade unions in the United States, working with their Mexican counterparts, are looking to identify those cases, and we'll see, whether this does in fact become an effective mechanism or not once we see a few cases go through the process. But I think it is interesting, and I think just my last point, it is interesting. I've taken a look at, as you know, the EU is going through its first dispute settlement with Korea under the EU-Korea FTA, and I've looked at a number of the initial objections made by Korea under that it sent to the panel of experts, and many of them reflect many of the objections that were made under the U.S. CAFTA arbitration. So I think to the extent that the language was borrowed from U.S. agreements into European agreements, the Korean government is obviously aware of that and is looking to also apply a very limited interpretation. The panel has not ruled yet, and I think it will be a very important case in the development of the jurisprudence in this area. But I think the lessons that have been learned under the USMCA from the mistakes that have been made in the past in the US, I think do provide some interesting lessons for the UK and the EU as they move forward. So I'll end it there. Thanks.
Thank you very much for that, Jeff. I'm sure that will again stimulate many questions, and I'm sure our next speaker too will pick up on some of those themes. So I'll move swiftly on to our next speaker, who is Aristea Koukiadaki from Manchester University. Aristea is a senior lecturer in employment law. Her main interests are research in comparative law and industrial relations. Together with some colleagues, Aristea contributed to the bit in the Institute's Manifesto for Labour Law, which deals with supply chains, and that will be an issue that I'm sure leads nicely on from what Jeff was just saying. So over to you, Aristea.
Thank you very much, Kad, and I would like to thank very much, of course, the Institute of Employment Rights for the invitation to participate today in this very useful, I think, an interesting discussion around labor standards and trade agreements. So given, of course, what's going on in the UK at the moment, both in terms of Brexit and also, of course, the trade bill that Ruth mentioned earlier, the topic couldn't have been, I think, of greater importance and significance. So as Kad actually said, together with a group of colleagues and I would say good friends, we proposed and put forward a number of recommendations when it comes to the regulation of supply chains, including in relation to the regulation of trade agreements as well. So in these proposals, we identified more or less the need, I guess, to put forward more progressive policies to tackle the issue of labor standards in trade agreements. So on the basis of this work, I thought it would be useful to talk today about some of these ideas and particularly focus on the case of global value chains. So we all know that value chains, of course, are complex, diverse, and they are fragmented. On the one hand, it has been argued that those types of forms of production can be actually an engine for economic growth. At the same time, though, failures within these types of production networks have contributed to significant decent work deficits. So, for instance, problems around occupational health and safety, collective bargaining, minimum wages, or other kind of the application of living wages, and working time issues. So, given these issues, the starting point for our work for the manifesto was the idea that the structuring itself of value chains creates an environment that is conducive to worker exploitation. So explicitly acknowledging this, we think is a crucial and necessary step for any kind of measures that we want to put in place for dealing with the issues around trade agreements, including as they are related to global value chains. Now, in the case of trade agreements per se, which of course is the main focus of our discussion today, these have been traditionally, of course, as I guess all of us know, these have been silent on the issue or the relationship between, on the one hand, labor standards, and on the other hand, value chains. So despite a growing academic interest in this respect, and there has been actually some very interesting literature that also, Ruth mentioned in terms of the work by Harrison and others, there has been very limited effort, or there have been very limited attempts at the policy level to link those two issues together. So to link and to establish a relationship from a policy perspective between the impact and I guess the relationship that trade agreements may have in respect of labor standards in the context of value chains. A variety of factors we think could be responsible for this type of silence at the policy level. The most obvious explanation is, of course, that global value chains are not seen by the trade negotiators as actually being intrinsically, I guess, connected to the types of labor violations that we see in the context of those types of production networks. Of course, we all know about the empirical evidence today that disputes that, and there is actually sufficient evidence, of course, to suggest that there are actually significant violations that are linked to the way that those products and services are sourced and are distributed. A second and related possible, I guess, explanation for the lack of policy interest in this respect, which is, of course, common also to the discussion around labor standards more generally in trade agreements, is that labor provisions, as I guess both Ruth and Jeff also mentioned, are not seen as significant by the negotiators in trade agreements. So, of course, in the context of trade agreements, they are primarily interested in pursuing purely commercial objectives. A third possible explanation is that even when labor standards are actually addressed in the context of trade agreements, the instruments that are used to address those types of problems are not, of course, effective. And again, of course, I think that has been discussed already today. So irrespective of whatever perspective, I guess, we adopt in terms of explaining that silence, in terms of the lack of linkage between those issues, we think that it's now clear that those types of limitations in the traditional governance approach when it comes to labor standards in supply chains or value chains, I guess, should actually require a comprehensive kind of reorientation and overhaul. So what could it mean in terms of possible reforms vis-a-vis trade agreements? First of all, we believe that there is actually a value in mainstreaming labor issues in those types of agreements. So rather than isolating labor issues to social chapters, as it's currently, of course, the case, we think that mainstreaming them into the rest of the trade agreement would allow the development of a range of different policy mechanisms to tackle those types of protective gaps when it comes to labor issues. This, though, will not be enough, we believe, if it's not accompanied by a radical, essentially, overhaul of the objectives that those types of agreements pursue. So we're not saying that trade agreements should continue as they are in the form that they are, because of course there are significant limitations. But we think that rather than promoting simply trade liberalization, they should actually be used for other objectives. So, for instance, social and environmental sustainability. We can then consider specific mechanisms through which those types of objectives can, of course, then be attained, or I guess be pursued. Some of these mechanisms address directly the case of labor standards in global value chains, and some others are broader in terms of affecting a variety of labor standards in the context, again, of course, of trade. So first of all, we think that human rights assessments should be made before agreeing to establish economic cooperation with other countries. So we know, of course, like that these days we have the debate about like the trade bill, and unfortunately the UK government has been like unwilling, as Ruth also, I guess, like alluded to it, to actually consider even including issues related to social, environmental, and human rights aspects in that legislation. Secondly, we should also consider pre-ratification requirements or measures that make ratification or even continuation of agreements on economic cooperation broadly conceived conditional on legislative or other domestic reforms that seek to improve labor standards. This could go actually as far as promising to promote and improve, for instance, like working time regulation by reducing working time. That's like a kind of like a commitment that has been made, for instance, in the context of the Council of Europe, the European Social Charter. Fourthly, I think it is important, I guess, to reconsider, as I guess like has been said already, the mechanisms for monitoring of compliance with labor clauses. So using again like economic incentives that Jeff like mentioned in the case of the revised now agreement between Mexico, Canada, and the US, but also of course like carrots, using carrots of course like in terms of like incentives. And then it's also of course like important to consider also dispute resolution mechanisms. So this could include, for instance, union employees being able to enforce labor-related provisions if, like, of course, like there are cases of labor violations. So if, of course, like, and that's a huge discussion, if we want, or if it's impossible to get rid of like the investor-state dispute settlement kind of mechanisms, why does it have to be that like capital investors can only access that, and why shouldn't labor like be able to access that as well, an alternative kind of form? Then there are of course other actually mechanisms that could address directly the problem of labor standards in value chains. And Jeff actually, I think like if I remember correctly, like has made a very kind of I think interesting proposal when like I think you proposed some years ago about using or introducing certain kind of fora for the monitoring, the review, and also actually the application of sanctions vis-a-vis specific firms that have a significant kind of presence in a specific market, in a specific sector, and they are considered significant for that particular segment. So it could be possible, I think, to imagine actually like a action that goes beyond the state-to-state kind of paradigm that exists today. So to conclude, I guess like because time is limited, I think that there was a recent report, or well, I guess like a couple of years ago by the ILO that basically like suggested that labor provisions in trade agreements do not lead to a reduction or I guess other kind of detrimental effects on trade flows. So if future agreements in the UK, but also beyond, are to include meaningful commitments on labor rights for workers in the UK, its trade partners, and also the value chains, then we think that the bar must be set much higher than the current approach in the UK in particular, but also, of course, like in the EU and the US, because I guess like our proposals go much further than that. So thank you very much, and I look forward to the discussion as well. Thank you.
Thanks very much for that, Aristea. You're quite right. We certainly need to raise the bar in terms of standards, both here and in proposed trade deals. I'm going to move swiftly on because I know we are short of time. And our final speaker this evening is Tony Burke. Tony is the Assistant General Secretary of Unite the Union. He has been a full-time official, for years. He is President of the Confederation of Shipbuilding Engineering Unions, Vice President of Industrial Europe, and an EC member of Industrial Global. He's a member of the British TUC General Council and Executive, and is currently takes the lead on employment rights for the TUC Executive Committee, and he's a member of the Labour Party National Policy Forum. Tony, how do you find time to go to work? And thank you for finding the time to join us here tonight. So over to you.
Thanks, Cad, and thanks very much for the invite to speak at this meeting. Seems that we've been doing trade stuff all day. Some of you know the Labour Party held a series of briefings this all day today on trade agreements, much of it centering on the Brexit deal. But this is an opportune time for us to have a look at where we actually are on trade. And I would just want to say this, that up until a few years ago, in the UK, trade agreements didn't normally appear on our radar. It was obviously the NAFTA agreement, those that followed trade union activity in the US and Canada began to spot something was going on, and the WTO demonstrations. But TTIP was the linchpin, if you like, that really started people thinking about what they actually mean and what the employment rights issues were. So we can all speculate as to what Johnson will do if he comes back with a deal from Brussels in the next few days. One thing I would say, Cad, is that it won't be an oven-ready deal. It will not be a no tariffs, no fees. It will be very, very thin. And I think that we will have to continue trying to find some form of agreement with the EU over a longer period of time. And the question mark of trade, of employment rights comes into any deal we do with the European Union. As you know, the Conservative Party have a view that they want to unshackle themselves from Europe, and in particular employment rights. If you want to test that out, just read Dominic Raab and Priti Patel's Britannia Unchained, and you'll see exactly where they're going. So I just want to take an opportunity, Cad, to give you a quick run round on trade agreements and what the TUC in particular is doing and saying about each of them. You don't need to take notes because I've supplied a list of links with all the TUC press releases and comment that's been made by myself and others on various agreements. Well, as you know, besides the Brexit talks, there are the rollover discussions going on, the trade agreements that roll over from the European Union, and reference has been made to Canada and Japan. And we've already signed that agreement with Japan. And we've got to say that it fails effectively to enforce workers' protections as we would want, and public services, and offers very little in the way of tariff reduction. And again, with Canada, we know there are some problems in regard to employment rights. One area that I want to focus on, somebody earlier on said, I think it was Ruth, why on earth are we wanting to join the comprehensive progressive trade agreement with the Pacific Rim countries? Well, I'll tell you why. They've got to have something. In or out of a deal, we've got to have some replacements. And the Tories are grasping at anything at the moment. If I can tell you, you probably know, we signed a rollover agreement with Northern Macedonia this week, and we've just signed an agreement with Egypt, and we've also got an agreement, I understand, with the EFTA countries. That's Liechtenstein, Iceland, and Norway. But one of the areas that we are talking, two of the countries we're talking to is Australia and New Zealand. The TUC team is having meetings with our union comrades in those countries, and it's very important. In Australia and New Zealand, there is some consultation with unions, not massive, but there is some. And it's important that we find out what is going on, because in the long run, what Johnson wants to do is get a trade deal with Australia and New Zealand worth very little, but that gives them an in my view, into the CPT agreement, because that's where they need to go. And bearing in mind, if we go into that, it's already up and running, and we'll have very little to be able to say about it in the long run. It's been referred to, we've signed an agreement with the East Africa, and again, you've seen the way that the UK behaved. They bullied Kenya into signing up for that deal against the work of the NGOs, and I think we'll see more of that in the future. Now, colleagues, before I go on to the USA, and Jeffrey made a good point and good explanation of the replacement NAFTA, this is the list that the TUC believes the government will try to get trade agreements with in this period directly after if we get a deal with the European Union. Singapore, Vietnam, the Mercosur countries in Latin America, including Brazil and Argentina, and also with Turkey. Turkey has a customs union. We will be out of that. There's got to be some form of relationship there. I'm not quite sure how they're going to do it, but it's one of them. The other one is India. There's no doubt that they will want to try to reach an agreement with India, and the price will be, as you all know, India will seek opportunities for young people in particular to come to the UK to study at our universities. I don't have a problem with that, but I think that is something that they'll want to move on to. And of course, there are other countries that they are lining up to talk to. Some of them may appear to be inconsequential, but of course, the two most consequential ones is the USA. And I don't want to go through what Jeff has just said. I doubt very much whether, I mean, it was floated around. If you remember, Liam Fox said we could join NAFTA. That's not likely to happen. I think the possibility of us joining or concluding any form of an agreement with the USA on trade is not highly likely. I don't think it's on Biden's radar, irrespective of what Johnson does. The bigger prize for Johnson, for Biden, of course, is a deal with the European Union, and obviously focus on what's happening in China. In China, can I just say that sometimes we think it's just so far away, it's impossible. China is now the dominant party in the RCEP trade agreement, trading bloc in South Asia, massive. And they have not only got that basis, but their trade agreements that they will do, and they will drive a very hard bargain, is based around investment through Belt and Road, i.e. buying up infrastructure from China going into Western Europe. That, I'm absolutely certain, that is going to happen, and that will be the price. But again, I don't think China will want to bother too much of trying to reach an agreement with the UK. I think their priority is going to be doing something with the EU, as we see through their investment strategy at the moment. So, comrades, I think there is a lot to do. And I think the detail that's been gone through by the speakers so far, and this is just a broad brush, you could actually do a whole 2-day, 3-day seminar on this and write books about it. Because one thing is absolutely certain, we have got to learn to do trade agreements. It's no use Johnson and Gove and the others thinking that we can swashbuckle around the world like Sir Francis Drake and Sir Walter Raleigh, putting countries to the sword and saying that's what you're going to do. They found it hard enough with the EU, and other countries, smaller countries, will not necessarily roll over. And I think that we'll find it much more tougher than they say. None of them will be a walk in the park. None of them will be the easiest trade deal to do in living memory or in history. And one of the important things is trade unions have got to be at the table. It's already been said, the government keep us away from any negotiations. They allow some employers in, but they're going to try to keep us away. The scrutiny of trade agreements, as somebody said, is going to be limited. I think if they go to Parliament with a deal, it will not be a line-by-line deal. It will be a straight up and down vote. And I think that that's going to prove to be controversial in the long run. We could talk all night about what Labour should do. We could talk all night about what the terms of Brexit, the Brexit deal should be, but that's for another day. As I say, colleagues, a lot of the press releases and the documentation on these trade agreements will be in the chat line, or go out to people who are on, have got email addresses, and you'll see some of the thinking of the TUC, of my union, Unite, and our joint union with the United Steelworkers in America called Workers United, which works very well. That's why we formed that organization, so we can keep each other informed. So thanks very much, Cad, and I hope we got a time for a couple of questions.
Thanks very much for that, Tony. I'm sure that we have. I'm aware that Ruth needs to leave us fairly soon, and I'm just trying to see if we have any questions specific to her. Have you noticed any, Ruth, in the chat box?
There was one from
Oh, there you are.
however, I don't think it's a question I can answer. It's about a local government pension scheme using its money wisely to promote green benefits whilst also getting the best deals for pension members. But that's not really the area that we focus on. The only thing I can say is watch carefully the procurement chapters of trade agreements, because they limit how you can use your procurement contracts to do the kinds of things that Pauline's talking about.
Smashing. Okay, thank you for that. And there is another one, which also looks like it is from Pauline, this time to Aristea. How can we use the Social Value Act that makes public sector contracts to those companies that have better ethical and more transparent supply chains?
Can I? Yeah.
Absolutely.
Thank you. Yeah, I think Nika, it's, thank you very much for the question. The Social Value Act, of course, Nika, I guess when it was introduced, it was introduced for the purpose, I think, of improving, the big society. If I remember correctly, it was actually a policy introduced or an act introduced by the government of David Cameron. One could see it actually in this kind of light, using it as a way, to incentivize social enterprises and other kind of community-based organizations to compete for those types of contracts. Unfortunately, though, the act, I think, from my understanding, hasn't been used to that effect. Its effect actually has not been that significant, and that's has to do with the fact that it's basically defective in terms of its institutional design. Because the Social Value Act basically does not require procurers to actually incorporate social value considerations in the procurement process. It merely asks the commissioners to consider whether it would be useful or not for the particular kind of, procurement contract to incorporate issues of social value. So in that sense, it provides only a very weak incentive for procuring organizations to actually incorporate social or other kind of standards in their procurement practices. That doesn't mean that, of course, some organizations haven't used it to promote living wages or other kind of for instance, no 0 hours contracts in specific sectors in local authorities. But I think as an act, from the perspective, of the legal kind of framework and the legal kind of stipulations, I would say that it's a relatively weak kind of piece of legislation. Yeah, thank you.
Yes, that's the problem with legislation, isn't it? So to Jeff, there's been a couple of suggestions that there'll be no UK-EU trade deal. What do you think? Do you think it is there? That is one, but there is another one too, which says, you were focusing on enforcement mechanisms going down to the companies. And there's one that says multinational companies change their head office location to avoid litigation for their practices in certain countries. How can we enforce legal action against them adequately?
Yeah, those are good questions. As far as the US-UK trade agreements, yeah, I have not heard the Biden administration speak on this issue. I mean, I think you're right that if there is any trade priority, it'll probably be a renewed effort at the TTIP. But I'm not aware. But again, I'm not on the inside track, and I see a former colleague from USTR is on this webinar, so maybe she has some insights on this. As far as this head company jurisdiction question, I mean, I think the USMCA model doesn't really matter in this case, because it's really looking to are there rights violations of freedom of association, collective bargaining in a covered facility, in Mexico. So it doesn't matter if the headquarters of that company is the US, Taiwan, Brazil, is asking in Matamoros or wherever, has a violation of freedom of association or collective bargaining happened here? If it has, we can, petitioners can file a complaint. Mexico will be given an opportunity to address the labor violations in that factory in Matamoros. If they don't, then there are further procedures that can go forward up to kind of an experts kind of panel that will review it and make a determination whether there was in fact denial of rights and therefore a potential firm specific sanctions.
Smashing, thank you. Tony, as you know all too well, the UK government is already in contravention of numerous ILO obligations, as I said at the beginning. I'm guessing there are no guarantees that we can enforce. How do we get the government to uphold those international standards in trade deals that they're not willing to stand up to for the UK?
One of the things we've got to do, Cad, is keep pushing through the trade unions, through the TUC, to have an involvement in a seat at the table in some capacity to push that forward. Hopefully, at some point, we'll get a Labour government who will have to deal with these issues, and I think that we will get a hearing. I certainly think that they'll have some inclusion, and that's the indications we've heard from Emily Thornberry today. But I think we've got to use every institution that we've got. I think we've got to do it wherever we can, through the International Congress of Trade Unions, through the European TUC, through Industrial, through all of the other global federations, and keep pushing. But it's important, I think, that we make people aware in this country of just what is at stake. We've had 40 years when we've never had to do this. And all of a sudden, we've got a crisis on our hands. 4 years to try and solve it. And it's now the media that are taking interest. I think what was said earlier on today, and I just want to quote it, there's no question that the original Tory idea was to create Cayman-on-Thames. It's as simple and straightforward as that. But they're not likely to be able to do that because the EU have made that very, very difficult. But they'll continue to try to do these things. And it's going to be up to the trade unions to push for a seat at the table, to push the arguments, and to make sure that the ILO conventions that can go into the agreements do go into the agreements, so at least we've got something to argue back with in the long term. I think that it's going to be, without the European Union, come what may, it's going to be a long learning curve. We're the only country that's not trying to join a trading bloc. We've actually come out of all of them. We're going to be on our own, trying to find our way. And this sunlit uplands that Boris Johnson keeps telling us are just around the corner, well, we'll have to wait and see.
Thanks very much for that, Tony. Well, look, 4 excellent speakers, very good discussions and presentations, but we are out of time. Tony very usefully sent us a whole load of links to put into the chat box. They will be circulated along with information about this event in the near future. There will be a final slide that comes up that tells people how to join, because as Tony just said, the important thing is bringing the collective strength of trade unions together and popularising knowledge and information about the trade deals and other labour standards. And that's what IER hopes to do. That's been our role for the last 30 years. We will continue to do that. So please sign up if you're not already a subscriber or a member. As I say, the final slide, here you go, has information on how to join us. If you sign up to our weekly news brief, you will get information about forthcoming events, forthcoming books, how to follow us. So can I just say thank you to our speakers for giving up their time and their knowledge so generously, and we hope to see you and the audience again in the near future. So thanks and goodbye.